So I think we can start. Other people keep on joining, so we can start now, I think.
Sure.
Okay, so hello and good afternoon, everyone. So I would like to welcome you all to today's workshop on intellectual property rights and IP management for startups. My name is Wasim Haider, and I'll be your host for today's session. So I am a second year BBA student and a team member of events and logistics team in ECEL. So ECEL is an initiative under the Center for Innovation and Entrepreneurship. IIC-Jamia Millia Islamia is an organization that strives to impart knowledge about entrepreneurship and startups. So our guest for today's session is Mr. Azam Ghani. Welcome, sir.
Thank you so much.
So Azam sir is a strong innovation supporter and IP visionary. Together with being an innovation supporter and IP visionary, Azam sir is a core IP strategist. He is among top 300 IP strategists of the world. As per 2017 IEM Strategist 300 list. I think someone's mic is open. If you can please switch it off.
Shiraz sir, आपका mic on रह गया. Okay, please continue listening.
Yeah, so he is among top 300 IP strategists of the world as per 2017 IEM Strategist 300 list. And he's also the founder and executive director at International Intellectual Property Law Association. So he advises his clients in IP development strategy, IP management strategy, and IP monetization strategy. And he works closely with the CTOs, R&D heads, partners, IP councils, and licensing managers of Fortune 500 companies, IP monetization firms, or general IP firms and law firms. So we are very fortunate to have you with us, sir. And thank you for taking out your time for this workshop. And hopefully we will learn something insightful today. So now I'd request you to please start with this session, sir. Thank you.
All right. Thank you so much, Wasim. Thank you so much for the introduction. First of all, good afternoon, everyone. Before I start this presentation, I would like to understand, how much understanding of intellectual property, the audience has. So you can just raise your hand and say that, you know about the intellectual property, and then you have some knowledge, like you heard it, whatever. You can just raise your hand. I just want to know how many of us know what is an intellectual property.
You can write in chat box, or you can open your mic and tell also.
Yes. All right. So looks like, we do not have any hand raised or maybe any message in the chat box. All right, great. So what I planned was I planned this presentation from the very basics. So let's just start with it. So what I'll do is I'll take you from the very basics of the intellectual property towards the IP strategy for the startups. So let's just have a look. So about me, I'm the founder of Metaso and International Intellectual Property Law Association. I recently graduated, like before the pandemic. I graduated from University of California, Berkeley. That's one of the premier college in intellectual property laws. And then I tried doing MBA 3 times, but I failed every time there. So I dropped FMS, University of Southampton, UK, and of course, our beloved JMI, CMS as well. And I graduated in electronics and communication in 2007 from Jamia Millia Islamia itself. So once again, thank you, Shiraz and other team members for inviting me. It's always a pleasure to get back to Jamia. All right, so let's learn what is intellectual property. All right, so I hope that everybody knows what is a property. Like, the simple things, car or land or bike or anything which is, you can touch, that is your property. Okay. So now we need to understand what is intellectual property. So intellectual property is something which is created out of your intelligence, right? The things which you have thought out of your mind, the things which are new, those are all called intellectual property. right? I hope you got the basic idea about the intellectual property. Any confusion as of now? So, at least you've got a basic idea what intellectual property is, right? Anything you create
Yes.
out of your mind. So let's just look at the examples of intellectual property. Okay. So here we have, your technology ideas, your company's brand names, slogans you create, design of a car or design of a bottle, software you write, music you create, the books you write, and Basmati and Kolhapuri are something special. Those are also intellectual property. So, if you notice over here, everything is created out of mind, like ideas, technology ideas, those are created out of your mind, out of your intelligence, right? So there's the brand names as well. So you create brand names, right? And slogans for the companies as well. So for example, in McDonald's, we have I'm loving it. That's their slogan. That's again, their intellectual property. And then we do have, we see latest car designs and everything. You get intellectual property around those car designs as well. So, not just the creation of the mind is intellectual property, rather, if there is a group of people who is creating something new, that is also intellectual property. Say, for example, Kolhapuri Chappal, that is the creation of the mind of the people of Kolhapur, of a particular area. So then this is also the intellectual property, right? So I hope it is pretty much clear to everyone what an intellectual property is, right? Anything created out of mind, which is new, and you have got the right on it, right? All right. So now we need to understand how these intellectual properties are categorized, right? So there is a different category for technology ideas. There is a different category for slogans and brands. So if it is a slogan or brand, it will be called as trademark. If it is a technology, it will be called as patent. And then if it is a new design of a car or a bottle or any other product, so that will come under design. Now, if you have something created something in software, that software will be copyrighted. The music is copyrighted. You pretty much heard about music cases like somebody has copied the music, or even in YouTube, if you upload something, YouTube blocks that if it has some copyright issues, right? If it is copied from some other place. So same goes for the books. Books have the copyright. Now these special things like the Basmati or Kolhapuri Chappal, these are all called geographical indications because they originate from a particular geography, people of the geography, right? That's why they are called geographical indications. So I hope it's pretty much clear the distinction between all these 5 types of IPs, right? Okay, so there is one more secret IP. Probably you guys are aware about it. Coca-Cola recipe in secret business process, right? Nobody discloses it. Nobody discloses the recipe of Coca-Cola. It's been there for hundreds of years, and there are some certain business processes as well. So, does anybody try to know the Coca-Cola recipe? Tried something at home, but it wouldn't work, of course, right? Because that's their trade secret. We call this intellectual property, which is secret. Business hasn't shared it with anyone. We call it trade secret. Now, just a wild guess: what kind of intellectual properties will be used by a startup? So let's go back to our list of IPs. So let's look at here. So we have patent, trademark, design, copyright, geographical indication, and the last one is trade secret, which is not on this page. So just a wild guess. Anybody, you can write in the chat box, or you can just raise your hand, and then we can bring you in the discussion and then see what do you think. What kind of IPs will be required by a startup, right? Any guess? Divya Jyoti, sorry. So let me just try to open. What's that? So Wasim, can you just okay? Divya Jyoti, trademark. Fatima says it's a trademark which will be required by the startup.
So I think design and patent.
Design and patent, right? These two are also there, right? Okay. So both of you are right, actually, Divijyoti, you are correct that we might need design and patent, and also as she said that we will need the trademark. Now, see, depends on your business. You know what kind of business you're trying to do. Say, for example, if you are planning, say, an electric scooter company, right? A brand new scooter you're planning to launch, those are electric, and then those can run 1,000 kilometer in one charge. That's like a dream, but yes, that's possible someday, right? So what all things you want to protect, right? One, you would try to protect the technology which you have created by which the scooter is running for 1,000 kilometer, right? So we'll try to protect the trademark for it. So patent for it. Patent is for the technological ideas, right? Now you will sell that scooter by certain name, right? So you'll call it maybe electric bike or some other unique name, and you would want that nobody should use your unique name. Nobody should copy your unique name. So then you will file the trademark as well, right? You'll try to get a trademark around that name. And of course, when you have a new design, right, of the scooty, you'll try to protect the design as well, right? So the things which the startup need, those could include the patent, those can include the trademark, and those can include definitely the one second, let me just go back, and the copyright as well, because you might have a piece of software as well in it, right? So majorly patent, trademark, design, copyright, and the trade secret, the last one which we use. So and some point you don't want to disclose this thing to anybody, so you keep it as a secret. All right, so let's look what are actually the IP rights. What does the IP rights do? So what does the IP right do is like they protect your rights from being copied by people and the businesses. So you get a protection when you create an intellectual property. Now the question is, who gives you the protection? Any guess on it? Who gives you the protection? How we can say that it is protected? Devijyoti raised hand again. Devijyoti, if you can type it, that will be okay. Judiciary. Fatima said judiciary gives us the protection. Who else? Who else can give us the protection? Government. That's exactly. So the Devijyoti said that it is government. That's right. So the judiciary ensures that you get the right once somebody infringes on it. But before that, the governments plan the policies. The government creates the laws, in the parliament, and those laws actually help you protect the IP rights. So there are government offices. Every government in the world has its own office, which protects the intellectual property right within that country. So if you look at over here, so there is a government office in the United States, which is called the United States Patent and Trademark Office. There is intellectual property office in India, which has the office in Dwarka as of now in Delhi. There are 4 offices in India. One is in Kolkata, one is in Delhi, one is in Chennai, and one is in Mumbai. So there are 4 offices within India. So if somebody needs to file a trademark or a patent application, they need to file in any of these 4 offices. So similarly, in China, we have the Chinese National Intellectual Property Administration. And so similarly, Canadian or Intellectual Property Office of the UK. WIPO is a little different. WIPO is a group of organizations, group of countries. They They give us a collective rights to the intellectual property. You'll get to know about this more, maybe like once you go deep into the intellectual property. Okay, so now you've got a basic idea what an intellectual property is, how it is created by your mind, and what kind of things can be intellectual property, and what does the intellectual property do, and how it gets the protection, who gives you the rights, right? So now let's look at this. As we discussed, IP protections for startups, they can include patents, trademark, copyright, design, and trade secrets. Now, if you are using a company name, so you need a trademark. So let's look at what are the intellectual property opportunities for a startup, right? So now in terms of a startup, when you think about it, so at times you work with a company and you also create your something own, right? So at that point of time, you are trying to create your startup, and then you're utilizing the resources of your existing employer. So that, you need to remember, you need to avoid that kind of scenario where you're utilizing the resources of your existing employer, because whenever you join a company, they always sign an agreement where they say that anything you create out of the situation, out of the resources utilized by the company, they'll be the owner of those intellectual properties, right? So now when you're creating a startup, you need to ensure that everything goes into the name of the company, right? Nothing goes into the name of the founders, because the later, say for example, there are two co-founders in a company and the dispute happens. Now, what will happen is, like, once somebody got the patent or trademark registered in their name, they'll say that, okay, bye, I'm taking this trademark away, and that's my company. I'll just create another company. I'll just start using this trademark, or maybe the patent. So you wouldn't do that. So everything, the patent and trademark, every intellectual property should go into the name of the company, right? The company, the startup you create. And similar to the employer, you also need to sign the agreement of your employees and each of the contributors of your company, so that you ensure that everything is in the name of the company. We cannot afford to lose the intellectual property of the company by giving the individuals the right of the intellectual property, right? Right. So now, if we look at the name of the startup, right? Of course, many of you would love to start your own company, and you would need to understand, and probably you already have a basic idea that, before choosing any name, you need to do some Google search so that nobody else is using that similar name, right? So other than the Google search, you should also go to the trademark search websites, the government websites. There you got to search the name you're trying to put for your startup, right? If it is already there, you shouldn't use that name. And also, the one easy technique is, like, you can go to the godaddy.com and then check if your name is available. So if the name is available, .com name is available, most likely, nobody else has created the trademark yet on that. And, if the .com name is not available, which simply means that somebody else has already started using that name, and we should avoid using that name. So first, try to find a .com domain for your startup, right? So, it's very, popular that the name of the company should be memorable and distinctive. Now, whenever I give suggestion to my clients, I say that there is a rule of 8. There should be 8 characters in your brand name. You look at the big brands, Apple, 8 or less than 8. Google, 8 or less than 8. Microsoft is an exception, a little more than that, right? So any other big brand, Tata, just 4 characters, right? And Reliance, less than 8, maybe like 8, right? So every big brand, they have a rule of 8. They wouldn't go beyond 8 characters. My company, Menteso, again, less than 8, but it's not that big yet. Hopefully, it will grow big as well. So Now, when you are stuck up and you feel like you need some help in it because you might not be able to search on the Google, government website, so get a help of a trademark lawyer for the trademark search, right? So in India, the trademark search, if you hire a lawyer or if you go for some chartered accountant, they generally charge around 1,000 to 2,000 rupees for searching that trademark in India, right? So that's very cheap in India. So you can definitely go for a trademark lawyer or a chartered accountant who can search for the trademark for you, right? So, I mean, of course, your brand name has to be broad. Say, for example, if you want to keep a name of a startup and then you want to keep a name like, say, for example, itservicescompany.com, right? Now, in future, you might start other things like, start a software selling, or maybe other than the IT services, you might plan some other services. So your name should be like broad, maybe like common, maybe some say mindsolutions.com. So Mind Solutions can include some other solutions as well, not just the IT solution. So try to keep the name broad and easy to remember. Okay. So now, in terms of patent strategy, we need to plan, what kind of strategy we want, right? There is a defensive strategy and there is something called offensive strategy. In offensive strategy, you go out and try to put your competitors in the lawsuit, right? And then you try to stop your competitors by using your intellectual property. Like, say, for example, you have created a patent or trademark. If your competitor is using your technology, you can just go ahead and stop your competitors. So in defensive, what you do is you utilize your intellectual property to protect yourself from others so that the others cannot, sue you. So for example, if you're planning to, again, launch that motor vehicle, like electric scooter, you would ensure that you have the technology rights with you. You're not copying somebody else's technology, right? So you would definitely plan the defensive strategy in terms of when you're launching your product into the market. So another strategy about the patents is like, at times the startups do, try to create thousands of patents for no use. So we always advise to focus on the core product and innovate around that, so that you save your cost in patent filings, right? So now another effective tool which we can utilize, to save the cost in the beginning is a provisional patent application. So what happens in a provisional patent application, like, whatever idea you have, you just file that application, and within 1 year of that, you have to file the complete application, right? So that complete application is also called the non-provisional application. Now in US, there is something called track 1, where you just pay some special fee, and if you are planning to go to an investor or someone, right, who wants to utilize your technology, so for that you go for a track 1 patent. Within 1 year you get a patent, you just pay in some extra fees, right? Now, say for example, if you have filed a patent in India and then you want to file that patent internationally, and say for example you have plans to launch your electric vehicle in some other countries like US or China, so you need to go for the international application as well. Now the rule for the international application is that if you have filed the patent application in India, and then within 1 year of that filing of patent application, you need to go for the international application as well. Any question till this point of time?
Yes, if anyone has any question, you can ask till now.
Okay, so let's look at the investor's perspective. We can pass the questions, towards the end. So we have got Shishir Singh Shekhawat. What about the Chinese knockoffs? Right. So see, the issue is like, if you want to protect your invention, in different companies in different countries. So what you need to do is you file the patent application within that country itself. Say, for example, if you want to protect your invention in China, then you must file the Chinese patent application as well, right? Now there is another copies of the KFC and others. So see, in that case, the name has to be distinctive. These companies like KFC and Starbucks, they drag people like very strongly into the lawsuits. Say, for example, if you have heard of it, there was a guy who called Sardar Baksh. Sardar Baksh started a coffee chain which was similar to the Starbucks, and they had a similar logo. Instead of that lady in the logo, they had that Sardar guy, and then the Sardar Baksh was pretty much popular as well in India. So now Starbucks, filed the lawsuit against them because they had the rights in India as well. And that case went on. That company was stopped from selling the coffees by the name Sardar Baksh because that was very close to the Starbucks. All right, so now let's look at the investor's perspective. What the investors think when you, as a startup, go for the investment, right? So they check one important thing, as we discussed in the beginning. When you're trying to create the IP, create it in the name of the company. The investors check it, right? Whom you have allocated the IP. Do you have the IP in your name or in the company's name? They do the proper due diligence before giving the money to you. So they see that if there is something which is should be a trade secret for the company, have you taken proper measures to protect the trade secret or not, right? Now, what plans you have if you are found to be infringing on somebody else's invention? They check those things as well, and they check how much IP portfolio you have. Do you have a trademark or not? Do you have patents, and how many patents do you have? Because this whole portfolio increases the complete valuation of the company, right? And then they always look that whether you have created a strong IP strategy. What is your burden to the research and development, and then the creating the IPs, and if you're using the qualified IP professionals or not, or you are just filing the IPs yourself. Because the problem is, like, at times the jargons or the write-ups of the IP is a little complicated. Without studying, you cannot do it. So you need to go deep into the intellectual property, understand it, how to write to the patent office, how to communicate with the patent office. Then only your IP will be in good shape, right? So now we have this thing called open source, and people try to use it while creating the softwares. Now we need to understand there is a peculiar thing about the open source, though it is generally free and it helps in the development, but there is an issue with the open source licenses. When you use it, the open source license at times says that you need to make it public. If you're using this code and if you're modifying this existing code, we allow to you, but you have to make it public. Now imagine, you have created a different piece of software, and then as per the license, you will have to make it public. So there is a potential IP risk in it, and we should not use it. So the best policy around the open source is like, define what kind of software you can use, define a clear-cut policy in your startup, so that people understand what kind of open source they can use and what kind of open source they cannot use, right? And now it is equally important to monitor and manage the IP assets. So you have filed the patent application, you have filed the trademark application. Now you need to ensure that these applications are live. These applications are responded to the patent offices or the IP offices timely, because when you file a patent application to the patent office and then you say that this is your idea, you have created this, do you think that patent office or the examining authority over there would simply agree to it? No, right? They would definitely say something and say that, no, this is not yours. We have already found something relevant to this. So when they send this kind of letter, this is called rejection letters. So these rejection letters, the attorneys, the patent attorneys or the IP attorneys respond to those rejection letters. Those rejection letters have, timelines attached with it. And then they say that you need to reply to those rejection letters within 3 months or within 6 months. So you need to ensure that those timelines are met, right? So how do we start, tracking ideas in a startup? Is like you start using a collaboration tool, like ideas collaboration tool, pretty much available online. There are app call is one of that. So you start using that within the company, and people share the ideas on it. You define a proper workflow in your company, right? The ideas come over here. Somebody who is there, an IP manager, will check the ideas, will discuss with the director, and then after the director approval, that ideas will go into the prosecution, like they will go to the prosecution attorney, right? So that's how you start managing of the ideas. So you need to plan, how you want to use the intellectual property, which you have created, how you want to manage it. So one thing we discuss is about the defensive strategy, where you create this IP to protect yourself from others by, so that they do not infringe on you, or they do not bring in a lawsuit on you. So another strategy of creating the IPs is like you generate a new revenue source out of it. So for example, if you create a lot of innovative ideas, you can actually license them out. Somebody else who is interested in those technologies, they can, buy the license from you, or they can buy the patents from you. Now, these things are, enforceable when you actually, pay the maintenance fee for these IPs on a regular basis. So what really happens is when you get a patent or a trademark, you get it for some initial years, 2-3 years, and then after that you need to pay the maintenance fee. So there are tracking for the maintenance fees as well. So that's the reason, you use a software for tracking the deadlines and dates for filing the patent application, or you hire an IP attorney or IP professional so that they simply can keep track on these kind of things, right? Now, with the monitoring and management, IP timings become very important. As I said, that there are deadlines attached to every response from the patent office and the examiner. You need to respond to those deadlines within timeline. And we also need to, plan the filing of the intellectual property. Say, for example, you're doing some research and development in your company, and that research and development, is still not yet over. And of course, it is first to file rule these days. Whoever files first gets the rights on the technology. So what you would do is you would try to file it as early as possible. But if you file it too early, your technology is not ready, and then it can undermine your application, because you will not be able to explain the things clearly in your patent application, right? So we need to be very sure of our paying our maintenance fees, and we need to, if we need to file some international application, we need to ensure that we file that within 1 year of the application, right? And keep use of the software so that you get notifications about the timings, which are, the nearby deadlines. So IP disputes, right? We have talked about, like, you are infringing on someone, someone is infringing on you, and then there is a dispute arising out of it. But, though being a lawyer, we love the lawsuits, we play into the lawsuits, but we never advise startups to go into the IP disputes, because you're just starting up, and it can definitely drain your time and energy. Right, it can eat up your most of major resources of the company. Like, your major directors and top-notch management will be involved into that litigation, because without them there cannot be a litigation. So rule of thumb is like, rarely go into the dispute, try to avoid it, never ever try to go into the IP dispute. You find it emotional when somebody is using your technology, right? And then you feel like you should definitely go against them, but that's not advisable. Don't play with the emotions. Think deeply around it, because this will be problematic for you. It will divert your focus from your core business. Don't go out of the emotion. Now, go into the litigation only if it looks like it's going to be beneficial. Say, for example, if you have an invention, that invention has been used by, say, for example, Apple, and you feel like, if you file a lawsuit against the Apple, you might be able to generate like $5-10 million in 6 months to 1 year, and which your company might not be able to generate. And if you feel like that's really beneficial, go ahead and do it, right? Otherwise, you should not do it. So we say that it's a sort of an atomic bomb. If you put a trigger on it, it will destroy your company, because it's just your startup, and then it'll eat up all your resources in time. Okay, so we always advise get a professional advice on it. All right. Now, as I said in the earlier as well, that if you file a patent application, if it doesn't follow the procedures, if it doesn't follow the guidelines of the patent office, even if you file the patent office will reject it. It will be of no use, right? So it's better to get that reviewed by a professional, right? And there is, importance of maintaining the patent. So, for example, I said after 3 years, the patent needs a maintenance fee to be paid, right? If you forget to pay the maintenance fee, then that particular patent will be called as abandoned, and then you might not be able to get the benefits of that patent application, right? So why you need IP professionals? Like, because they create the good IP strategies, and then those good IP strategies, end of the day, help you in attracting the investors who actually see the whole IP strategy before investing into your company. And another reasons to use the professional is IP laws, and through any law, and then their interpretation changes almost every 6 months. That happens every 6 months. There is some new law, there is some new case in the court, and when the court declares something, the laws change, right? And when something happens in one way after the court ruling, the things start happening in the other way, right? So every 6 months the rule changes. The application style, the application write-up, the communication, the way of communication with the patent office changes, right? So that's always advisable to use IP professionals, right? And another thing is like, most of these IP professionals are available for the free initial consultation. Just go ahead and utilize them. Talk to 4 or 5 of them, not just 1 or 2, and then just don't disclose your idea to them, and then just tell them that you're planning these things. What strategy do you suggest? Talk to 4 or 5 of them, and then you'll get to know who is the best and who can utilize, who you can utilize. All right, so it's pretty much from my end for the startup. So I'll be more than happy to take up your questions now and see.
Yes, sir. It was really nice, sir. It was very insightful. Thank you.
Great. Great.
So now, if anyone has any question, then they can ask. They can write it in the chat box, or they can open their mic and ask. Okay, Divya Jyoti has some questions. You can ask.
Yes.
Hello, sir. Good afternoon. Sir, one thing
Yes,
I'd like.
good afternoon.
Sir, can you patent any procedure? Can you patent any service or any procedure?
So, Divijyoti, we cannot patent any procedure. So there are 4 things for an invention to be patentable. So there is a clear defined rule for it. 1, it has to be novel or new. It has to be, it has to have some industrial application, right? It should not be obvious. And because, the procedures, those come into some, mathematical sort of formulas. Those are not patentable. Any abstract ideas are not patentable, right? So that is not patentable.
Okay, sir. Sir, can the ideas of manufacturing be patented? Like somebody's manufacturing something or somebody's transforming something. That type of ideas can be patented?
So, Divijyoti, see, those ideas per se are not patentable. However, the machines you have created, like the improvements in the machine, the design of the machine, that can be protected. The machine, if it has some different utility, that can be patented. If the machine has some new design or something, then you can protect it by the design patent. Yeah.
Okay, sir. Thank you.
Okay, we have one question
Thank
in
you.
chat box, I think.
Yes.
How do smartphone companies copy big companies like Apple, Samsung, especially in their design?
Right. So that is a pretty popular case. A court in the U.S. The judge was Lucy Ko. She actually granted Apple $1 billion against the Samsung. So that was the case happened when Samsung created a phone with just single button design, because that design was patented by Apple way back in like 1990s. A smartphone with just single button, that was just a thought only, and then those things were not imaginable at that point of time. Somebody could not imagine beyond BlackBerry's keypads, but Apple did it. Apple thought about it. Apple got it patented, and there was a big lawsuit against the Samsung when they started making it. So now what really happens in those kind of scenarios, because now Samsung is also developing a lot of technologies, right? So they are also getting a lot of things patented. Now what happens is they either file a cross case against the Apple, right? If Apple files the lawsuit on them, then the Samsung files the lawsuit against them in some other technologies. Now what really happens is they come onto the table and then decide it. That is one way of resolving it. Or they try to resolve it within the courts itself. Courts ruling in Apple's favor, the other courts give the ruling in Samsung's favor. And then what really happens is, like, if the Apple goes to the South Korea or some favorable country of Samsung, they will get the lawsuit against them over there. So that's how it happens. You end of the day, you get a deal with them. You have to give them the licenses when they have started paying it, or they pay the royalty or some licensing fee to the other companies.
So there is one more question: how to deal with first copy products?
First copy products. Okay, those are again, you're talking about, I guess, the products which are like fashion products, maybe like first copy of jeans or first copy of some other products, right? So see, those are trademark issues, right? They already have a brand, and I have seen companies, Louis Vuitton. So what they do is, like, they hire some detective agencies to track, who is actually selling their duplicate products, and they chase them like anything, right? Those detectives create a complete report. They even buy the products, the copy products, and then provide the complete report to the management, and then the management files a lawsuit against them once they're sure. And that's how they stop it. Also, if you try to sell something on Amazon, if the Amazon get to know that you're selling the copy product, not the original product, the first thing they will ask you the bill, so that they can identify if you really purchased this product from the legal sources, or they will close you down. They close down your business totally. So the best way to buy original products is to buy from the company's websites only, so that you're 100% sure that you're buying from them. For example, I never buy a Reebok or any other thing from Amazon or anybody else, because Amazon does not go deep down to track who is actually selling the A copy product. So If you just buy from their main website, you're almost sure that they will not be, say, giving you the fake products.
Yes, it's always better to buy from the original website.
Yeah.
So, any other questions, if anyone has?
All right. So what I have is, like, I have my email ID in front of you, azam@mentorship.com. I'll be more than happy to take up your questions offline as well. If you don't have some questions right now, feel free to reach out to me, and I can always redirect you to the right person who can help you whenever you are in IT needs, right? And I wish you all a very good luck for all your startups. Whenever you need me, I'm there.
Thank you, sir.
Thank you so much, sir.
Thank you so much, everyone.
Thank you so
You're
much,
welcome.
sir, for
Thank you.
joining us for the session, and it was really great talking to you. Thank you so much.
Thank you, sir.
It was good. Thank you. All right. Bye-bye. Take care, everyone.
Thank you, sir.